Hello to one and all present over here. My name is Laksha Jolly and I'm an intern in Lexis & Co. I'm a third year law student at New Law College, Pune, and the topic we're going to discuss today is about trademarks. The topic is essentially everything about trademarks. So, let's begin. Indian trademark laws provide an extensive and extraordinary protection to the trademarks that are well known and protects and safeguards from the various threats of infringement under Section 29 of the Trademark Act and passing off under common law principles and so on, also under Section 135 of the Act. The Act specifically protects against two levels of threats. They are against registration of similar mark under Section 911, against misuse of any well-known mark. Provisions made for well-known trademark under the Trademark Act define a well-known trademark under Section 2(1) ZG, subsection ZG, as a well-known trademark in relation to any goods or service is a mark which has become of substantial segment of the public, which uses such goods or receives such services that the use of such a mark in relation to any other goods or services is like to be interpreted as implying a relationship between those goods and services and the person using the mark in relation to the first mentioned goods or services in the course of trade or rendering services. There are further provisions made to safeguard against the registration of identical or similar trademarks. Under Section 9 of the Act, Section 9, subsection 1 of the Affidavit 1 provides for an absolute refusal of registration of similar mark. The provision in this section provides protection to well-known trademarks in a way that if a new trademark has a similar face value, that is illusionary and misleading mark which makes it harder for a person to distinguish one good from another, will make it a ground for not allowing the trademark to be registered. Under Section 11 of the Act, Section 11, subsection 2 provides protection of well-known trademarks across all the classes. According to this clause, well-known trademarks have to be recognized across all the classes of goods and services. Section 11, subsection 6 takes all the factors into account which determine whether a trademark is well known. This was adopted from WIPO in the year 1999 as India is a part of World Trade Organization. The factors are listed below. Knowledge about the mark in various sectors of the public, duration, extent and geographical area in which the trademark is prevalent, duration, extent and geographical area in which the trademark is promoted with respect to the goods and services in which it applies. Trademark registration or application for trademark registration to the extent that they demonstrate use or recognition of the trademark. The record of successful enforcement of the trademark's rights include any evidence that the trademark has been recognized or well known by a court of registrar. Section 11, subsection 9 contains the conditions which are not required for the purpose of granting well-known trademarks. These conditions are: the trademark has been used in India, the trademark has been registered, the application for registration of trademark has been filed in India, the trademark is well known and known in any other jurisdiction other than India, the trademark is well known to the public of India. Thus, it can be said that a trademark has not been necessarily have a business in India or the trademark registered in India. Instead, the masses as a whole should know the trademark and there should be a transport reputation of the trademark. Section 11, subsection 10 contains the obligation on the registrar that in a case of dispute or infringement has to be protected the well-known trademark as opposed to the identical ones. The registrar also has to take into account the notice and the intentions of complainant and the opponent. The filing of well-known trademark follows the New Trademark Rules 2017. A trademark owner can directly file an application for a well-known trademark to the registrar. The application has to be accompanied with a statement of case, relevant documents, evidence and a fee of ₹1 lakh. All of this has to be filed online through the e-filing system. Once it has been filed, the same will be considered for hearing in accordance with the document submitted. Remedies for trademark owners on infringement of well-known trademark are as follows. Prevent the registration of confusingly identical trademarks across all the classes of products and services. Request the infringement mark be removed. Prevent the trademark from being used in the name or logo of any company or organization. The damages for retaliation are also being given to anyone who would qualify for the same. In various situations, the courts have ruled the punitive damages as necessary to deter infringers from exploiting and causing dilution of well-known trademarks. The court held in Time Incorporated v. Lokesh Sarma Srivastava, 2005-30, PTC, Delhi. that in intellectual property proceedings, punitive and compensation damages must be awarded. In this case, the court awarded the plaintiff rupees 5 lakh in punitive damages and 5 lakhs in compensatory damages for infringement. That is all for today. If you want to know more, please stay tuned. Thank you.